Good afternoon, everyone. My name is Mark Waletsky, and hopefully everyone can hear me, and everyone is also able to see the slides. We are going to be talking today about keeping employees safe and free from inappropriate workplace conduct, and if folks have questions throughout the presentation, there is a chat function. I will be absolutely doing my best to responding to those either as they come in or potentially at the end. But if you do have questions, feel free to use that chat function, and I'll go ahead and address your question. So that's me, just so you can, I guess, get a visual of who's talking on the webinar today. I am a labor and employment attorney at Holland & Hart. I've been doing this now for a little over 20 years, and I really handle kind of all aspects of these types of issues. And what I mean by that is I work with folks like you and clients on a regular basis dealing with these issues as they arise in the workplace, excuse me, and really trying to either investigate, resolve, or address these issues before they turn into litigation. And I also address these issues in court if we're unable to resolve these things at an earlier level. So with that, we're going to jump into the topics we're planning to cover today. And really we're going to start where all of this gained steam recently, which is the Me Too movement. I also want to talk about and differentiate between what's unlawful versus what may be just inappropriate or disrespectful, because there really is a difference between the two. Sometimes employees don't always realize that. Sometimes you would respond in the same way, regardless of whether conduct is unlawful or just disrespectful or inappropriate, but it's important to know the difference. We're going to talk about the different kinds of sexual harassment that can occur in the workplace, and we are also going to talk about potential liability for those different types of harassment. And maybe most importantly, we're going to talk about steps that you can take to prevent workplace harassment. That really, I think, is the key, because if you're like most people I work with on a day-to-day basis, the last thing you really want, number one, is to have any inappropriate conduct or sexual harassment going on in the workplace, but number two, you really don't want to get involved with or dragged into a lawsuit. Here's our disclaimer, and this is just the reminder that this isn't specific advice, but just kind of a general presentation for educational purposes. All right, so let's jump in. The Me Too movement has really just caught on fire. Alyssa Milano and many others kind of helped to start and this movement in terms of gaining a lot of really press and notice for this issue, and the issue really comes down to women and men who have been sexually harassed or treated inappropriately at work or by others in a position of power over their careers. Here's a picture of Time magazine that named the Silence Breakers as the Person of the Year. And obviously this shows just how much media coverage has been generated by and about this movement of people coming forward and speaking out about sexual harassment and other types of inappropriate conduct. Obviously, as most or probably all of you have seen, these accusations have hit people at the highest levels. It's been politicians, movie stars, TV actors, newscasters, and journalists. It has really hit a lot of folks at the highest levels, and frankly, some really startling stories have come to light through that whole process of behavior that was not only tolerated for many years, but apparently well known at some of these organizations and about some of these individuals. And I would be willing to bet that, at least with respect to, for example, NBC, Fox News, and some of these other organizations, they had policies in place prohibiting harassment, sexual harassment, hostile work environment. And yet, we all saw that some of these top stars and top people had been engaging in what appears to be just absolutely awful and unlawful behavior for years. So one of the things we'll talk about, and we'll circle back to this at the end, is having policies is good, it's necessary, but having a policy alone is not the be-all, end-all to avoid sexual harassment and to ensure that your organization may not have issues with it. So let's start with what really is harassment or discriminatory behavior versus just rude and inappropriate conduct. And the question on this slide is all rude conduct unlawful? And so let's start with an example. Let's say a manager or let's say a physician said to a nurse, you're lazy, you're stupid, my 4-year-old could do better than you, I don't know why you were hired, but I'm going to do everything in my power to make your life miserable. Obviously, not appropriate under any circumstances, but is that kind of thing unlawful? And the answer is probably not, although it could be, depending on whether this physician or manager was targeting certain people based on their gender. And that's really when workplace behavior becomes unlawful, when it's based on a protected characteristic So sexually explicit jokes, posters, remarks, things of that nature, those are going to start crossing the line into not just rude or inappropriate, but unlawful behavior. Ethnic slurs, same thing, that's going to cross the line. Mocking a person's religious practices or beliefs, segregating workers based on race or gender, all of those things cross the line from just plain inappropriate and wrong to unlawful because they're based on a protected characteristic. And there's three sets of discrimination laws that can come into play here. We often focus on a federal law, which was created by Congress. That's Title VII, and that's enforced by the Equal Employment Opportunity Commission and federal courts generally. But don't forget, state laws out there, and in many, if not most states, the state law parallels federal law. So it contains the same type of protections, and sometimes even more protections than are allowed under federal law, including, for example, sexual orientation discrimination. So those same laws are enforced by the state fair employment agencies, the counterparts to the EEOC, and by state courts as well. There's also sometimes city and county ordinances to keep in mind. I frankly don't often see those being the basis for a lawsuit because typically the state and federal law provides the remedies that people are suing under, but it is important to keep in mind if you happen to be in a city or county that has those local ordinances or regulations, make sure you're aware of them and that you're complying with them. So in terms of sexual harassment, focusing in on that, since 1964, sex discrimination in employment has been unlawful under Title VII. Since 1980, the EEOC has made it clear that sexual harassment is a form of sex discrimination that's prohibited by Title VII. And in 1986, the Supreme Court of the United States recognized that a hostile work environment based on sexual harassment is, in fact, sex discrimination. So this is not obviously a new law. All of you know that. This is not anything that's, just in the last few years. But as demonstrated by the Me Too movement, there is obviously still conduct that occurs in the workplace and in other areas that is just prohibited and not appropriate. So the law is there, but there's still conduct that's occurring in violation of that law, or at least there, and I should say, there are times when people think that there's violations of the law when there really wasn't, because there happened to be rude or offensive behavior, but not sexual harassment. So there are different types of sexual harassment that can occur. One is quid pro quo harassment, which just means that someone is asking for sexual favors or a relationship in exchange for a job, a promotion, or is essentially taking some adverse action against an employee for rejecting in advance a request for a date, a request for a relationship. This involves supervisors, managers, those with power over a subordinate employee who make make this a condition of the job or some term or condition of employment. The second or other type of harassment that can occur is a hostile work environment. And this is the one that I tend to see more frequently. This is when there's just inappropriate conduct that crosses the line because it is unwelcome. It's based on a protected characteristic, for example, someone's gender or sex, and it's severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. So let's unpack that a little bit because obviously those are all part of a legal test that has been developed over time. In terms of determining whether conduct is really severe or pervasive, the courts will look at whether the conduct is frequent, how severe it's been, and whether we're talking about physically threatening or humiliating conduct versus some offensive utterance. So in other words, if you have someone who has made an inappropriate joke and it's targeting women, for example, or an inappropriate statement targeting women, and it happened one time, that typically is not going to be enough to constitute sexual harassment or create a hostile work environment. It may be completely inappropriate, and there's no question that you can and should take action even if something does not rise to the level of sexual harassment under the law or hostile work environment under the law. But if it's a one-time thing, if it's infrequent, if it hasn't been particularly severe, it's unlikely to rise to the level of a hostile work environment under federal or state law. Now, on the other hand, if you have a single incident that is really severe, an assault, for example, that one incident can be enough to cross the line and create a hostile work environment. In terms of determining whether or not it's offensive, there's a couple of questions that are asked. One is, would a reasonable person find it to be offensive? And did this particular person who heard the comment, the joke was directed at that person, whatever it may be, did that person find the comment or issue offensive? The difficulty with this analysis, of course, is that at the time something occurs, someone may not indicate or say that they were offended. They may not show any indication at all. And then months later, a week later, a few hours later, they may say, you know what, that was really offensive, and I didn't appreciate that. And in those situations, you have to be careful, because if everyone took it as a joke at the time, but someone is telling you, hey, this, I think this is offensive, then you should act on that, even if at the time the person did not say that or have that particular reaction. So a question that sometimes arises is, well, really harassment is just the the manager or supervisor. It's someone. It's the CEO. It's the physician who oversees or supervises the nurse. It's the nurse who oversees the aide. It's someone in a position of power, and that's definitely a misconception. Harassment can occur from really anyone. It can occur from a coworker making statements or engaging in inappropriate conduct. It can be a manager or supervisor, but it can also be a customer, a patient, a vendor, or anyone else. And frankly, that last category, those can be the most difficult to deal with at times, because sometimes if you have a patient, for example, in a home health care situation, who is making inappropriate comments to or saying inappropriate things to a nurse who is caring for the patient, it can be very, very difficult to deal with those situations. But if you don't, your organization can be liable for that behavior, just as if your organization can be liable for the behavior of a coworker or a manager or a supervisor. So be careful to make sure and address any allegation of harassment, whether it's coworkers, managers, supervisors, patients, vendors, anyone else. If it's connected to the workplace at all, even if it doesn't happen at the work site, you really do have an obligation to deal with it. And just as a couple of other examples, if you have employees who are posting things online about another employee, that may be happening after hours. It may be happening on personal devices. It may be happening on personal social networks, Facebook or something else. But if you become aware that that's happening, you absolutely have an obligation to take some action, because it's employee versus employee or manager versus employee, and so it is connected to the workplace in that way. So another time this tends to come up is social events. If there are company-sponsored social events that are going on, especially ones where alcohol is involved, you have to be very careful. If you have people who are not acting consistently with your policies or your expectations, that behavior should be addressed just as if it had happened in the workplace. Even if you have a non-formal event, but let's say informally your employees are going out after work and getting together, and at these informal get-togethers, there's inappropriate behavior and conduct occurring, I'd want to be aware of and be advised of that as well, so that you can take appropriate action and ensure that it is not going to negatively impact the workplace, and ensure it's not negatively impacting those employees who may be offended or may be treated inappropriately at those events. In terms of liability for harassment, there are different rules and different tests that apply depending on who is harassing or allegedly harassing the employee. If you have a supervisor who is harassing a subordinate employee, and there was some tangible employment action, and that can be someone was fired, someone was denied a promotion, someone was denied a transfer, someone was disciplined, someone wasn't given a raise. I mean, it can really be a variety of things. If that occurs as a result of unlawful harassment by a supervisor, then the company, the organization, is going to be liable for that conduct. That's why this is so important, because even if, as a company, you generally wouldn't tolerate that, if you've got a supervisor behaving badly, the organization can be held liable. If there was no tangible employment action, so let's say there was no firing, no raise, no demotion, nothing like that. It was just inappropriate jokes, inappropriate comments, maybe inappropriate texts or emails. Then you are liable unless you exercised reasonable care to prevent and promptly correct any harassment, and the employee unreasonably failed to complain or avoid harm. So what that all means is, in a nutshell, you've got a good, solid policy that prohibits sexual harassment. It's been out there for employees. Employees know about it. You've trained them on it. There's reporting procedures where employees can report to individuals other than their own supervisor. There's a no retaliation provision in your policy. So you have all that out there, and yet the employee failed to complain or do anything about it. Now, a key issue that we see in these cases when an employee doesn't complain, let's say the employee doesn't complain, quits, and then sues you for hostile work environment, a lot of times we want to say, hey, we had a policy in place. We had procedures in place. We took this seriously, and yet you didn't give us a chance to do anything about it. The employee sometimes will come back and say, well, I didn't do anything about it because I know 5 other women who have complained about harassment against the same person in the last year, and the organization did nothing about it. And that can be a real problem. That can be a real problem for an organization, because if there is a history of, let's say, a supervisor, for example, or even a coworker just doing, well, let's say supervisor just doing, engaging in inappropriate conduct, saying inappropriate things, propositioning subordinate employees, and the behavior is not stopping, and there's no indication that the employer is doing anything about it, then that can be a real problem. So just be aware that, again, just having that policy in place is unfortunately not enough to really insulate you from liability if you have a harasser who is harassing your employees. In terms of who fits the role of a supervisor or fits that definition, there was a decision by the Supreme Court of the United States back in 2013 that says really anyone who's employed and has the authority to take tangible employment actions against the victim is a supervisor. So just because someone doesn't have the title of supervisor, and just because you may not consider them to be a supervisor, if they have the authority to take a tangible employment action, then there is the possibility of you being held strictly liable as an organization for that person's behavior. Now, moving to non-supervisors, there's a different test. You have a different test if this is coworkers or third parties, for example, patients who are not supervising the individual. And in those situations, the employer is only liable if it's negligent, which means you knew or should have known of the conduct and you failed to take immediate and appropriate corrective action. Now again, this is one of those things that could be difficult if you have again, a harasser in your midst. There's some coworker out there who isn't a supervisor, but who's going around telling inappropriate jokes, being too touchy with people. Maybe you have someone who says, "Oh, I'm just being friendly. Oh, this is fine. I can give people a hug, or I can give this coworker a back massage. She said her back hurt, and I just gave her a quick massage. She didn't, say anything about it." Those are the ones who present risk, and potentially a lot of risk, because a couple reasons. One, sometimes that behavior has gone on for a long period of time, and sometimes the person, the alleged harasser, is well liked by some people, but there's other people in the organization who are offended by the behavior. And sometimes that person who is, saying, "Oh, it's not a big deal," and "Oh, I'm just friendly," that can present a lot of risk sometimes, because they do see themselves as just being friendly. They do not see themselves as doing anything offensive or inappropriate. They're not intending to offend or to do anything inappropriate, and sometimes they're horrified when they learn of that, but sometimes they just brush it off and just say, "Well, that's just one person. That's just, so-and-so who, doesn't really, isn't very friendly." You really have to take care, even if it's someone who overall is well-liked, if they're engaging in behavior that is inappropriate. Even if it's just one person or two people who say, "You know what, I really don't like the hugs," you got to take action to make sure that doesn't continue, because before you know it, you're going to have someone who's been engaging in that type of behavior for an extended period of time, and then someone could come along and say, "Hey, employer knew about this for years. This guy's been doing the same thing for years toward women, and no one did anything about it because he was a likable guy." So just be careful about that. So also there is sometimes a question, and we touched on this earlier. What if there's a meeting, for example, and we give this example on this slide? A female doctor flirts with a new male nurse at a meeting, saying, "Oh boy, studying your anatomy is going to be fun." And maybe this is a very humorous physician, and everyone laughs. She's very well-liked, physician. People take it in good fun. Even the male nurse, who the comment is made to, laughs at the meeting. Is that harassment? Well, the answer is it certainly isn't appropriate, and it could rise to the level of harassment depending on if it becomes a more frequent comment, and if it continues over an extended period of time. That is definitely approaching, if not crossing the line, to unlawful sexual harassment, even if the male nurse who the comment was made about laughed at that meeting. That alone is not enough to say, "Hey, we don't need to do anything." And I don't know what your experience has been, but my experience has been in most of these situations where comments or statements are made at a meeting, the individual who was targeted or was called out often does not say anything at the meeting and often goes along and will laugh either for fear of causing a scene, being called out, whatever it might be. So it's not unusual in my experience to have that kind of thing happen. Now, what if the physician said afterward, meet me after work and we'll talk about how to put your career on the fast track, and then winks at him. And this could be any gender, it's whether male to female, female to male, male to male, female to female, it doesn't really matter. The problem that this raises is it's starting to look like, in the context of these other comments, that the physician is hitting on the nurse and saying, hey, come meet me after work and we'll see if we can do something for your career or promotion, this other job that you wanted, whatever it is. Again, that's the kind of thing that you're really getting close to, if not going over the line, to quid pro quo harassment at that point. Is this one statement going to automatically put you there? Probably not. But again, my experience is it's almost never just one statement. If it's a statement like this that's been made, there's usually a pattern of statements, and it sometimes can continue for a period of time. So let's talk about what you can do to prevent sexual harassment from happening in the first place, or at least ensuring that if there is some inappropriate conduct, it does not continue. It's easy to say establish a culture free from harassment. It's sometimes harder to ensure that you are actually doing that. It's important that the highest levels of the organization repeat and reiterate to employees that this is not tolerated and that this is not appropriate. And that can happen through annual, semi-annual, or other reminders from your CEO or leadership team reminding people about your policies and procedures. And that can happen just by virtue of the fact that if someone at a higher level is engaging in inappropriate conduct, it's dealt with, it's addressed, and it's stopped. Because if people see a CEO, a CFO, a head of some department getting away with inappropriate conduct, people looking the other way, that becomes very difficult to deal with. Very, very difficult to deal with, because that does not create a culture that's free from harassment. Other people may think they can get away with it, or other people may think there's nothing that can be done in this organization. So it's important that no one gets away with sexual harassment, regardless of their position or their importance to the organization. And again, I know that saying that is sometimes easier said than done. Sometimes you can have a physician that is a key part of your practice, for example, and this person is highly specialized. They are a phenomenal physician. They are important financially to the organization. They contribute in all kinds of ways. But if that person also is harassing employees, they're creating significant risk for the organization, and a risk that really shouldn't be ignored just because they happen to be particularly valuable. So we talked at the beginning about having a written harassment policy. Obviously, showing that there's zero tolerance for workplace harassment is important. Offer examples of unacceptable conduct. In other words, you can't email. You can't post jokes. You can't condition a term of employment on agreeing to a relationship or things like that. Make sure that you have 2 or more channels to report. That's critical, because if you don't, the employee may say, well, I didn't report anything because my supervisor was the one who was harassing me, and the policy says I have to report to my supervisor. And in that situation, not surprisingly, a number of people just will not report. So make sure you have 2 or more channels, human resources or your supervisor. I know some clients have anonymous hotlines where they can report things. Make sure that you have ways for people to, feel like they can do this, and let them know that there will be no retaliation. And that is really important as well. Obviously, training employees is key, and training them on your policies, giving them policies when they first become employed, when they are when they're at their orientation, having them sign off that they received the policy. Those are all important, but make sure it's not just new hires. Do an annual refresher. I can't emphasize enough how helpful those can be, especially if you get to the point of litigation, because when we're in court trying to convince either the court or a jury that you take this seriously, it's incredibly helpful to be able to say, not only did we have the policy, but we call that policy out in our orientation. We provide annual trainings that everyone attends, and in fact, this employee attended this year, because we kept the attendance sheets. And we also train our supervisors and managers on an annual basis on how to deal with these types of issues. So those are all really important steps to take, and really will put you in a better position, not only to ensure people are aware of and trained on your policies, but that you can demonstrate you take these issues seriously. Investigations of allegations can be key. And here's something that maybe all of you have experienced, but sometimes someone will come in and make a report and say, I want to share this with you, but please don't use my name, and I don't want you to do anything about it. I just want you to be aware that so-and-so has been too touchy-feely and making these jokes, and it really makes me uncomfortable, and I think, I'm not the only one who he's done this to, but please don't share it with anyone, and I don't want this person to get fired. Like I said, I just wanted to let you know. The response, and the only response to that, is you've got to investigate. Because number one, you're now on notice of inappropriate behavior. Number two, that same employee, if you don't investigate, will almost certainly not say down the road that I said don't investigate. The employee may very well say, I told them how serious this was, I told them I was uncomfortable, they did nothing about it. So take action. Don't promise someone complete confidentiality. That's another issue where sometimes they'll say, please don't use my name. Please, I don't want you to use my name. And what I tell people is, that you can respond with is, we will keep this as confidential as possible. We can't promise that we won't use your name because we do need to investigate this. But what we can promise is that we absolutely do not tolerate any type of retaliation. And if you believe that there's been any type of action taken against you because of this complaint, you need to inform us immediately. And if they say, you know, well, please, I don't want to have someone fired because of me, you can respond by saying, if someone is terminated, disciplined, or otherwise, this will not be because of you, it's because they engaged in conduct that was not appropriate in the workplace. So, you know, that's important to just let people know and to do your due diligence and investigate. Make sure when you investigate, you have a plan before you start the investigation. Very important, because you want to know who you're going to interview first, who you're going to interview in the middle, who you're going to interview last. Typically, you're going to want to get as much information as you can before you interview the accused. That tends to be the last person that you're going to interview. So come up with a plan, come up with questions, be specific in your questions. A lot of times people say, well, I didn't want to ask, you know, hey, did you say X to this person, because then they would know that that's the issue. But if you don't ask the specific questions, someone can attack your investigation after the fact as being insufficient. Because if you say, hey, have you ever made this an inappropriate comment, you know, just generally, and someone says, no, of course not. That's not the same as saying, hey, did you say to this person or anyone else that if you agreed to go out on a date with me, I would give you that promotion? That's a very, very specific question and an appropriate one to ask. Look at security cameras, time cards, other evidence. Find what you can find, other witnesses if there are any, and don't be afraid to reach a conclusion, even in a he said, she said situation. You might have to make credibility determinations, but you can and should do that. If you believe the accuser, that, you know, even if there isn't any corroborating evidence, but that person was more credible because their story was consistent, because of the things that they said, the details that they provided, and because the accused did not credibly deny the accusations, maybe said, well, I don't really remember saying that. I could have said something close, or, you know, no, I'm just not sure. I mean, you can and should make determinations. Now, you don't have to say that something constituted unlawful sexual harassment, but what you can say is that something was inappropriate and a violation of your policy. And it's very, very important, once you reach your conclusion, to follow up with the accuser, at a minimum with the accuser, because you want to be able to say, we closed the loop. You don't have to tell them what action you took if you did take action. In fact, you probably shouldn't tell them exactly what action you took. But you should let them know, we investigated your allegations, we interviewed witnesses, we reviewed documents, and we concluded either that your allegations were substantiated or they weren't substantiated. We took action that we thought was appropriate to ensure this behavior doesn't continue. Remind them of your non-retaliation policy and let them know if anything happens that they believe constitutes retaliation, they should contact you immediately. And you should confirm all this in a written memo, because I've had and defended cases where employers took all of these steps but didn't put that last step in writing, and then the employee said, no one ever followed up with me. And we had no documentation to counter that allegation, even though it was absolutely untrue. So just be sure that you go through that process and you document it appropriately. And consider, by the way, when you investigate, is this going to be a third-party investigator or is this going to be handled internally? If you have a high-level executive or someone else who you believe you really need a third party to do that investigation, then I recommend it, especially if you think that litigation is likely, because having that third-party investigator do that investigation gives the organization a lot of credibility and, frankly, a lot of coverage, so long as you take appropriate action if the investigator concludes that there was inappropriate conduct or behavior. And that could be terminating someone, that could be warning them, that could be sending them to additional coaching or training. You have all kinds of things you can do, but if you do nothing, that can really come back to haunt you. And if you simply settle with accusers consistently, at some point, that's likely to come back to haunt you as well, as we've seen from some of these very high-profile settlements in the entertainment and political arenas. Again, the action you take should be designed to stop the harassment, and that's really the issue. That's your goal, stop the harassment. And as long as you take action that is reasonably designed to stop that harassment, then you're doing what's appropriate. Now, if you take action and it continues, you take action again, it continues, you take more action and it continues, then you've got a problem. Because even though your actions may be in good faith, if it's not working, you got to take some different actions because you really want that behavior to absolutely stop. In terms of settlements, I've touched on this a couple times. Not all organizations are going to have the same issues that, for example, Fox News experienced with Bill O'Reilly, where there were millions and millions paid out over the years, and that was certainly damaging to its credibility. But if you are, for example, a community hospital or an organization, especially in a smaller community, and you have a history of settlements and suddenly one goes public, that can be damaging. That can definitely, there's a PR component to this that can be damaging to organizations. So I just say, I like to remind people, just be aware of that, that even though you're not, this big media conglomerate or a politician, the repercussions can happen and they can be real. Also, as a result of the recent tax reform, if you have a non-disclosure provision in your settlement agreement, and frankly that's common and we almost always do, then no tax deduction is allowed for that type of settlement payment. So just be aware, this is kind of the way of Congress saying to folks, listen, you want a tax deduction, then this has to be open. Otherwise, you can keep it confidential, but you're not getting any tax benefits or write-offs as a result of this. So we've got a few minutes left, and I wanted to open it up to any questions you may have. Hopefully you all have seen the chat function, and you can type in a question if you have them, and I'm happy to do my best to answer them. And for those who don't have questions or can't stick around, I want to say thank you, and thank you to everyone for participating in the webinar. I hope this was helpful, and hopefully you have either learned some new things or have been reminded of things you already know that are helpful in terms of dealing with harassment and that type of conduct in the workplace. And I see one question now about the interaction between medical staff bylaws and HR investigations. I'm not sure okay, so for example, there may be employees you can't fire, for example, physicians, because they have protections under the bylaws, and maybe there's due process protections. That can certainly present some challenges, to say the least, and that can be tough. You obviously have to follow the bylaws. There's no question. On the other hand, if you have a situation where you have someone who is not changing their behavior, you may not be able to fire them, but hopefully you can take some action against them in connection with their employment, either through discipline, additional education, coaching, or some action through the bylaws. And I've seen that happen. I've had that happen, where there are interpersonal conflicts that occur and behavioral issues that don't impact the care that's being provided to the patients, but still implicate your duty as an employer. So I'd say the way those two things interact is you still have to follow both. You may not be able to immediately fire a physician, but you still do need to take appropriate action. In terms, someone's asked if you'll get a copy of this presentation. Yes, it should be available on the website. If it's not, and what I mean by that is on our Holland and Hart website. If it's not, please email me. My email is on this slide, mbwiletsky, W-I-L-E-T-S-K-Y, @hollandhart.com. And I'll be happy to make sure you get a copy of this. Not sure if there's any other questions. I'm not seeing any come across here. I'll stay on the line for just another minute or two in case anyone comes up with any. But again, thank you very much. All right, seeing no further questions, I'm going to sign off. Thank you to everyone, and I hope you all have a great day.